a spiteful reason, even an untrue reason, which most people are shocked by, you can get
Right.
fired because someone lied on you. That is not against the law.
Hello and welcome. I'm Aaron Gartlan. This is the Trials Podcast. I'm here with attorney Forrest Taylor. This is the program where we feature and highlight the challenges that the injured face and how we meet and deal with those challenges. Forrest, what have you had going on this week? What have you been working on?
We've got several cases involving minors. In Alabama, you're a minor if you're under the age of 19. And anytime that a minor has a personal injury claim and you settle that claim or resolve that claim, it has to be approved by the courts. And there's a process that you go through, and we call that process, the hearing is called a pro-am hearing. And what the court does is, so you got a settlement with a minor, and the court reviews that settlement to make sure that it is in the best interest of the minor. And many times a court will appoint an attorney who's not been involved in the case to give an independent review of the terms of the settlement, and that attorney is called a guardian ad litem. But anyway, we've got several cases coming up that we've been able to resolve, and we're waiting for the court to set a hearing, again, a pro-am hearing, and many times, they only last 15 to 30 minutes, and the court typically has a lot of the information before the hearing.
I'd like to touch on a few issues with that case because I think it highlights the heart of the program, the heart of the podcast.
Right.
We, in every case that we handle, we want to make sure that our clients get the medical treatment
Right.
they need and the best care available, and also that they're getting the full value for their injury case or the full value for their case. Maximize recovery. Get the recovery as much as possible, the dollar value, and then any kind of reimbursements or liens that are out there that we get that reduced to
Right.
the lowest amount possible. And again, while ensuring they're receiving their medical care and treatment. I think this particular case highlights some challenges, again, that the injured face in the aftermath.
Right.
This was a case involving a drunk driver.
Right.
So again, on the surface, it would seem like that's an open and shut case. A minor is in an accident or hit by a drunk driver. Wouldn't that just be an open and shut case?
On the surface, it would appear to be. But in this situation, as we see in many instances, the driver had no insurance. We then investigated what the driver had been doing, in the hours leading up, before the accident. And the driver had been at a restaurant bar and actually was overserved alcohol, and which is in violation of Alabama law. And if you can prove that, then the restaurant or bar is responsible for the injuries caused by the patron that they overserved alcohol to. And there's all types of training, rules, and regulations that are intended to prevent bars and restaurants from overserving people alcohol. And in this situation, we did have to file a lawsuit. We did have to litigate the case. We went through discovery, and the evidence that we were able to uncover demonstrated that this establishment did overserve this patron who tragically hit our client, who was a child who was on a scooter, a little scooter that you push with your foot, just riding up and down the street, was hit by this drunk driver. So, again, like you said, on the surface, it appears to be a straightforward case, but the again, as we see so many times, it is the person driving didn't have insurance, and we have to look to see if there are any other responsible parties. And in this situation, the evidence supported a claim against this bar or restaurant.
And Force, one of the things to me that's so gratifying about this case, and I know you'll agree, if you remember when we first talked to the child's mother, she was really at her wit's end and had actually been turned down by
Right.
other lawyers. Other lawyers had told her, listen, it's a drunk driver. They have no insurance.
Right.
They have no assets. They're looking at jail time,
Right.
possible prison time. The odds of being able to
Right.
recover anything to help your daughter are, slim to none. So she had actually been turned down
Correct.
by several other attorneys before contacting us. So I know I just think for us that adds another layer of just satisfaction and
Right.
and what we're
Right.
doing.
And I think you touch on an important point is sometimes you get a case and it's like peeling back the layers of the onion. You're trying to, look at who is responsible. Is there insurance coverage available? So, yeah, I mean, a lot of times it is a very complex procedure, and especially in a situation like this. And then you've got to prove a violation. You've got to prove that the restaurant or bar then violated Alabama state law in the way that they served this patron alcohol.
And I think another layer, again, that demonstrates the challenges that the injured face. This child had over $100,000
Right.
in medical treatment, medical care.
Right.
And we're so glad that she was able to get that treatment. But, we had to make sure that any medical coverage available paid
Right. Exactly.
the bills and the expenses. And again, that seems like would be an automatic thing that would just happen, but you still have to follow up on that and make sure
That's
that
right.
everything's paid properly.
That's right, because what we don't want to do is leave the parents owing, just a large amount of medical bills. And in this case, we had to navigate not only the issues with the liability, who was responsible, but also we had to coordinate with our clients' health insurance to make sure that all the bills were paid to the extent that the insurer was obligated to pay those bills. But you're right. I mean, it can be as complex as the underlying claim. And one other thing that I wanted to mention, going back to the pro-ami hearing, if a minor does receive funds, the court has an obligation to make sure that those funds benefit the minor. Many times the courts will require that the funds be placed in an account that cannot be cashed in without court approval until the minor reaches the age of 19. One other thing that a lot of courts like is an annuity. And the annuity offers a minor several benefits. First of all, it protects that money till that minor reaches the age of majority. But if it's done properly and you put that money in annuity, the growth of that money is tax-free. So many times with our clients, we can put this in an annuity that really has a lot of benefits. When the child reaches the age of majority, we can extend those payments. A lot of times, get a monthly payment for decades in many instances, depending on how much the settlement was. But an annuity is just a powerful tool that we can use in these cases involving minors that maximizes, as you mentioned, part of our job is is to maximize recovery, and that's one way that we can do that.
Yeah, I'm glad you brought that up because that's something else that, part of getting ready for the hearing,
Right.
to get the court approval on this. We had a conference call yesterday with the child's mother and a representative of a annuity company to go over
Right.
various options to again help ensure that the child's receiving the maximum value, and it's done in a way that's going to best benefit her. And it's really, from a work and professional standpoint, the best feeling to remember that first conversation where, again, this mother's at her wit's end.
Right.
And then the most recent conversation that we had with her is, how do you all want to handle
Right.
this annuity? How do you
Right.
want to handle these structure settlement options? So it was really a good, and again, also highlighting the challenges, because even on the dram shop component, on the surface, that would appear to be open and shut.
Right.
But like you pointed out, that those issues had to be litigated.
Right.
Also.
Sort of switching gears, our practice, we mostly represent people who've been injured. We deal with a lot of workplace injuries that fall under workers' compensation. Sometimes there's a third-party claim, meaning a claim against somebody other than the employer. But we also get a lot of calls on just employment law questions. Somebody's been terminated. They feel like they've been unfairly terminated. And we're lucky today. We've got a guest who specializes in employment law, represents employees, and her name is Temple Trueblood. And we're really glad to have her on the program today.
Yeah, definitely. One of the things I love about being a lawyer is I feel like we learn something new every day.
Right.
Oftentimes it's things that maybe we didn't want to learn.
Right.
But Temple's one of the people that I can say I've definitely learned a lot from, and having the opportunity to,
Right.
Talk with her, work with her. So I'm really excited about your interview with
Right.
Temple today.
All right. Well, we'll go straight to the interview then. Today, we're fortunate to have Temple Trueblood with us. She is an attorney in Birmingham. Good morning, Temple.
Good morning, guys.
Could you just tell our viewers a little bit about, or give us a little bit of your background, your education, and professional background?
Yeah, sure. I'm an attorney up in Birmingham, Alabama, but as I often say, half bar card will travel. I do cases across the entire state of Alabama, as well as Panhandle, Florida, some Georgia and Tennessee. I'm admitted in the federal bars there as well. And 99.9% of my practice is helping employees or potential employees or ex-employees with legal issues that came out of their employment, usually cases or suits against their employer, for various violations of federal employment law, discrimination, harassment, wrongful termination, things like that. I've been doing it for about 25 years now. I'm a partner with Wiggins Childs, Pantazis, Fisher, and Farm up in Birmingham. I'm pretty active in the bar as far as employment law goes. I serve on the State Bar Committee for the Labor and Employment section. I'm also on the board for the National Employment Laborers Association for the Alabama chapter. I actually literally wrote the book on Alabama employment law. It was published through Lexis, which is a legal publication that most attorneys are familiar with. Be very boring and dry to anyone who's not a lawyer, probably. But I had the honor of getting asked to write that book and keeping it updated. But most of the time, I am either practicing in litigation in federal court, or I am serving as a mediator to help other attorneys resolve their cases that may be pending, employment or otherwise. In a quick nutshell, I mean, I have a whole host of stuff. I've been doing this a long time, but those are probably the main things.
Great. That's a very impressive resume that you have. The So you mentioned federal law, but let's start out. Alabama is known as an at-will state. Would you just tell our viewers what at-will means?
Sure. Alabama is what's called an at-will employment state. Most states in the union are at will. There's a handful of outliers that aren't, so it's not just Alabama for once. But at will employment in a nutshell means unless you have a written contract both parties have entered into, or you're a union member, or some public employees like employees of state or county or city entities, the rest of us, the vast majority of employees, are at will employees. And what that means is we kind of just have this mutual understanding. We may not have a written contract, we may not have a union contract, but we just have this kind of flexible understanding that I'm going to come work for you. I'm going to do X, Y, and Z. And then you're going to pay me A, B, and C for doing what I do for you. And that understanding is flexible. It can change. You can get promoted, demoted, transferred, fired, written up, told to wear a pink polka dotted uniform every Wednesday, whatever, as an employee, for a good reason, a bad reason, no reason, a spiteful reason, even an untrue reason, which most people are shocked by. You can get
Right.
fired because someone lied on you. That is not against the law. Or you can get fired for or demoted or whatever the case may be for no reason. They don't have to tell you why they're demoting you. They don't have to tell you why they're letting you go. The flip side of the coin is that if you decide you don't like the job, or you don't like the changes that have been made, or you're done as an employee in an at-will state, you can just walk. You don't have to turn in a notice. You don't have to work out 2 weeks. They can't pay for leaving. They can't make you work out anytime. You leave, and that company is then stuck with no notice and they have to figure out how to operate without you. And for some people, I mean, in key positions or mass workforces, losing your employees can be crippling. So that's kind of the
Right.
reverse side of the at-will coin. But most people that are going to work every day in the state of Alabama are at-will employees, which means they have a lot less rights than they generally think they do. Your employer can make a lot of decisions, good, bad, ugly, or otherwise, and it may not necessarily be against the law.
Yeah, you touched on a thing that I've seen a lot in my practice where people come to me and say, well, I showed up at work and I was fired. They didn't give me a reason. And there's got to be some remedy there. And there's just not a remedy in that situation.
Yeah,
Um,
just not telling someone why you're firing them is not against the law. They don't have to give you anything in writing. They don't even have to tell you why. They can just
right,
say, you're not coming back. And that is, in most cases, that is not against the law. Again, unless you have a written contract or you are protected by a collective bargaining agreement for a union, or if you are employed by like a public entity, like a city, a county, state, they have their own kind of internal processes that the rest of us don't really have, that
right.
are a little different. But for most of us, that is not against the law.
Now, when you were telling us about your background, you mentioned most of your practice is predicated, I think, on federal workplace protections. Would you just tell us a few of the more common ones that you deal with?
Absolutely. Yeah, since there are very few state laws in Alabama that protect employees, and everyone always gives Alabama a hard time. It's not just us. Most
Right,
states do not have a lot of laws that protect employees, except maybe California. Rhode Island has a lot. New York has some. But most states really don't. And so what you're left with are the federal laws that provide protections in the employment context. And the biggest one is going to be Title VII. That's just what we call it. It's Title VII of the United States Code, and it prohibits discrimination, harassment, and retaliation in the workplace if that discrimination, that harassment, or that retaliation is based on a protected federal characteristic. And those include gender, race, religion. Pregnancy actually falls in under there, although there's a couple new pregnancy laws that have come out in the last 2 years, which is about time, but because this Title VII was enacted in 1964. It was part of the civil rights movement, and it really hasn't been updated much at all since then. But religion's included in there, national origin, ethnicity, sexual orientation. Those are all protected categories. There's also the Age Discrimination in Employment Act, which protects people from age discrimination. Right. The Americans with Disabilities Act protects people from disability discrimination, harassment, being denied accommodations that are necessary to work, retaliation as well. Family Medical Leave Act is a big one. I get a lot of those cases. If you meet certain criteria, you get protected unpaid leave from your employer. They can't hold your absences against you. And then some recent pregnancy and related laws that have come out in the last couple of years. But those are probably the big ones I get the most on. And Title VII encompasses a lot.
Right. So. In this area, and probably a lot of areas across the state, the employers, it may be a small business. Is there a threshold on the number of employees that would trigger protection under these federal laws?
That is a very good and very important question that if you are a lawyer listening to this, you need to ask immediately up front. Right. Because there are. Title VII that provides the protections for gender, race, pregnancy, ethnicity, sexual orientation, religion, all of those things. The employer has to have 15 employees. If they have under 15, that law does not apply to them. Unfortunately, I have had people call me where they have called me and they tell me they have point blank been fired and told they were fired because their boss found out about their sexual orientation or their boss found out they were pregnant. But they worked for a company that only had 8 or 9 employees.
Right.
I can't do anything. They have to have 15. The Age Discrimination Employment Act is 25 employees. Family Medical Leave Act, they have to have a total of 50 employees located within a 75-mile radius. So if you've got multiple, locations right. or chain restaurants or things like that, you can add them up. FLSA, wage and hour overtime pay.
Right.
There's no number needed. There is one law, a federal law, is called 42 USC 1981. And so we always just call it 1981 because it's shorter. But that is a race discrimination statute, and it does not have a number of employees required. So for the most part, 15 is your minimum. There's a couple other, like I said, the FMLA and the Age Discrimination Employment Act that have it a little higher. But for most general stuff, at least 15.
If someone has felt like they've been discriminated against and they do fall under one of these federal laws, are there certain time restrictions they have to file a claim?
There are. And again, it depends on each federal law. And so it can get complicated sometimes I've been doing this for 25 years. So at this point I can probably recite them in my sleep, but if you're new to it, it can be a little confusing. And, for anything under Title VII, so again, race, gender, right. sexual orientation, religion, pregnancy, those things, national origin, ethnicity, also the Americans with Disabilities Act, the Age Discrimination in Employment Act, the new Pregnancy Workers Fairness Act, which just went into effect last year. Kudos to Congress finally for recognizing that. All of those, before you can even file a federal lawsuit on your claim, you are required under the law to file what's called a charge of discrimination with the Equal Employment Opportunity Commission, or the EEOC for short. And you have, and this is the zinger. This is the one that gets people. You have to file that charge before you can file a lawsuit. If you don't file that charge, you cannot ever file a lawsuit. So it's a hoop you have to jump through.
Right.
And you have got to jump through that hoop within 180 days, which is short, 6 months-ish, 180 days from the last unlawful act, whether it's an act of discrimination, an act of harassment, or an act of retaliation. You have 180 days to file with the EOC after that last act. And if you file on day 181, you're out of luck. You're not going to pursue that claim in federal court or anywhere else under federal law. So it's a short window. It's 180 days. It's 6 months. And if you don't get that charge filed with the EOC before then, chances are you're never going to get anything further down the road.
What happens after you file if you do file an EEOC complaint? What happens? Just walk us through the steps.
Yeah, the EEOC is a federal agency that's been tasked with, frankly, trying to help unclog the federal courts. The federal courts get they have a ton of cases. They have criminal cases. They have all kinds of stuff the federal government's doing with land and everything else, their internal agencies. And then you have the federal employment laws cases that, like I file, that take up a good part of their docket as well. And the EEOC is tasked with investigating the charges of discrimination or harassment or retaliation. And then they also have a really good mediation program, especially in Alabama the last several years, since COVID, really. The mediation program out of the Alabama offices of the EOC has really just blossomed. It's come under some new leadership, and it has been phenomenal. So sometimes
Great.
they are able to get the cases resolved without someone ever having to go file a federal lawsuit. But the process generally is you file your charge in black and white under oath, saying everything that you're saying that the company did that was illegal. And then the company submits a written response. They can produce documents, they can produce statements from witnesses if they want to. And then once that response is provided to me or to the individual who's filing the claim, the employee can submit a rebuttal if they would like. They're not required to, but they can. And then at the end and that's pretty much most of the investigation. There's not a whole lot of, I guess what most general people walking around think of as a, quote, investigation. Like they're not out rattling bushes and scoping up witnesses and finding stuff. But they review everything that's presented to them. Sometimes there are site visits. Sometimes the EOC investigator will go out to a company to do a site visit and interview people, but those are more rare than normal in my experience. And then at the end of the review period, the EOC issues a piece of paper called the Notice of Right to Sue. And they check a box that says either we found discrimination or we couldn't find it or we ran out of time. Because they also only have 180 days to complete their investigation.
Okay.
On day 181, if you tell them, I want my case back so I can go to court, they have to give it to you. And they issue this right to sue, and that is the piece of paper you need to be able to go file your federal lawsuit. So the process is kind of a lot of submissions in writing more than anything. And then you get your right to sue so you can go file the lawsuit if the case hasn't been resolved at the EEOC level.
How long do you have to file a lawsuit after you get the right to sue letter?
90 days.
So another short window. Yeah, very short window.
Yep. Typically, as soon as I get a right to sue, my office goes ahead and sends a Freedom of Information Act or a FOIA request to the EOC asking for a complete copy of their investigative file, because you can get that. That's public record under FOIA.
Right.
So as soon as I get the right to sue, we ask for their EEOC file, the investigation file. Normally, the turnaround of those is really quick, less than a week. I get that file, review everything to make sure there's no surprises, because sometimes you find surprises. Sometimes things come out that you didn't know about, or your client didn't know about, or your client knew about but didn't tell you.
Right.
So and sometimes there's stuff in there that makes your case even better. So I always review the file and then get that lawsuit filed within 90 days of the date the right to sue was issued. So it is a short window, but but normally it's plenty of time to go ahead and go through what you need to.
Oh, Temple, if somebody feels like they've been discriminated against, how would they get in touch with you?
Oh, with me, well, okay, my name is Temple Trueblood. I'm like the only one. So if you Google me, chances are you're going to
Right,
find me directly.
right,
But easiest way is you can email me. It's on my website. It's a really long email.
right.
Or you can call my direct line, which is 205-314-0514. But otherwise, or it's Trueblood at Wiggins with an S, Childs with an S.com. But honestly, the easiest is just to type my name in and
Google.
Google me. I'll
Right.
pop right up as the first one with this name.
Good deal. Well, Temple, I certainly appreciate it. I know that our viewers and listeners will find this very helpful. And again, thanks for being with us.
Thank you so much for asking me. It was great to see you.
Yeah, same here.
Forrest, I feel like that was an excellent interview, and it's really nice to literally, as Temple pointed out, we have the employment lawyer that essentially wrote the book in Alabama
Right.
on that topic. And, something that my dad, I probably heard over 1,000 times growing up: son, get a good education and help people. As a kid, I'm thinking, well, that's going to be in the classroom. But in reality, for me, that's been with the cases, the clients, the colleagues, the people like Temple that I've had the opportunity to work with or learn from.
Right. Well, I think it's, the employment law is a really specialized area of practice. You've just got to thread so many needles, as Temple mentioned, to have a claim. It's a very difficult area of the law, and again, that's why you have attorneys like Temple that specialize in it. And I think some of the takeaways that I get from our interview is you're an employer, especially smaller employers, have a lot of leeway in hiring and firing. But if you do feel like you've been discriminated against, I think the important thing, and this just is across the board, if you think your legal rights have been violated, you need to act promptly, because as Temple mentioned, you've got a very short window to get your EEOC complaint filed. Then you've got a short window to, if you do get a right to sue letter, to file. So people need to, if they feel like they've been discriminated against, they really needed to get their case evaluated as soon as possible.
Yeah, definitely. And it seems like those timelines, on the one hand, it seems like, well, that's a lot of time, but
Right.
but in the legal world,
It's not.
Yeah.
When you have to request documents, that can take 30 or 60 days. It's a very short window in the legal perspective. It is.
and not to mention, you're talking about requesting documents, because, we see this a lot in ordering medical records
Right.
and reports and so forth. And it seems like over the last year or so, things are taking longer. You can get
Right.
the request out in a day,
Right.
but you may not get a response. Sometimes it's weeks and months, or you
Right.
get something that's incomplete. So I think you're right. I mean, you need to take action as soon as
Right.
possible. Thank you for listening to the Trials Podcast. This is the program where we highlight the challenges that the injured face and how we meet those challenges in an effort to help you maximize your recovery and get the medical treatment and care that you need. If you have questions or concerns, feel free to call us at 334-699-4625 and to learn more about us, our wonderful clients and family, at GartlanInjuryLaw.com.